Okay, good afternoon. My name is Monica Crooms Mkhikian, and I am an attorney at U.S. Immigration Law Group in Santa Ana, California. And in the spirit of Valentine's Day, we are here today bringing you a presentation called So You Think You've Fallen in Love, a comprehensive overview of what it takes to bring a significant other to the United States from abroad. So we begin with an overview of options for how one can petition and bring their significant other from abroad. The first option, well, I guess first I'll say all of the options require either marriage or an intent to get married, an intent of marriage. So the first option we have here is listed as the fiance visa. And so anyone who is in the United States, who is a U.S. citizen and who is engaged to be married to someone who is living outside the United States, you can file a petition to bring them from abroad, and we'll get into those details shortly. The second option is for a couple who is in fact legally married. It doesn't necessarily mean or require that they're legally married in the United States, but someone who is legally married to someone living abroad can file a petition and bring them into the United States through consular processing. Alternatively, a couple who is married and both individuals are within the United States can also file an application for adjustment of status in the United States. And we'll get into these options with more detail now. So fiance visa eligibility requires first that the petitioner, so the person who is petitioning their significant other to come to the United States from abroad, is a United States citizen. There has to be evidence of an intent to marry within 90 days of the partner's arrival to the United States or the fiance's arrival to the United States and admission. The petitioner and the fiance must be legally free to marry. And what that means is that if there have been any past marriages, those marriages have to be legally terminated in order for the petitioner and the fiance to become married in the United States. And so many times we have folks who call and question or ask us about whether or not the United States legally recognizes marriages that have taken place abroad. And the answer is yes. If you were married outside of the United States will still recognize that marriage as a valid marriage. And so if there are several processes for getting legally divorced in the United States, even if the marriage occurred abroad. International divorces are a possibility for folks who perhaps don't have contact with their, ex-partner or their ex-spouse, although that's somewhat outside of what we do as an immigration law firm. We have several resources that we can refer folks to for, further inquiry or more questions about getting a divorce if necessary, an international divorce. Also, if the divorce ended with the death of the former partner, former spouse, then a death certificate will be required when filing the application for the fiance petition. Now, there is a requirement that the petitioner, the U.S. citizen petitioner, and the fiance have met in person at least one time within the 2-year period of filing the fiance petition. So you will need some sort of evidence to show that you've met. It could be in the United States, it could be abroad. It's not, there's no requirement that it be in the US, but the meeting must be in person. So unfortunately, during these times of COVID, when a lot of our interaction with other people is happening virtually, that will not satisfy the requirement that the meeting be in person. However, there is a waiver that exists, but it's only available if meeting in person violates your fiance's cultural or social practices or results in extreme hardship to you. So now I'm almost going to take back what I just said about COVID restrictions, but if the inability to meet in person is due to something that is called extreme circumstances or extreme hardship that would result to the US citizen, then perhaps there's a way around it. So definitely something to discuss with your attorney and to develop if that is the case in order to be able to qualify to file a fiance petition. Okay, so the fiance visa process is a 4-part process. The first step is filing the petition for a fiance. So that form is the I-129F. Essentially what the U.S. citizen, well, the U.S. citizen petitioner is the person who is asking the Department of Homeland Security to approve the petition and then send it or transfer it abroad to the Department of State so that their fiance can be admitted. And so what is required with a fiance petition is evidence that the couple, as I said previously, has met. And so that could be by, submitting copies of, itineraries for travel, reservations for hotel, photographs. Those are probably the most common forms of evidence. And then also you can submit any kind of correspondence between the petitioner and the fiance that would also indicate that they have met as well. Sometimes we get a little unconventional with evidence being submitted. I mean, that is something that's relatively easy to prove. It's easy to prove that you've met in person these days with just an airline confirmation ticket and a hotel reservation. But if for any reason those documents aren't available, then we can get creative. Facebook posts, so check-ins and Instagram posts are also things that in this social media age, immigration and the Department of Homeland Security also considers as evidence, as probative of the couple meeting in person. So once the petition is filed, showing that the couple has met in person and that they have an intent to marry, showing intent to marry can be accomplished with a declaration by each the U.S. citizen and their fiance, and then also, letters from friends and family, reservations from, churches, banquet halls, just any type of place where one would expect that some sort of marriage ceremony was taking place, but anything that's indicative of the marriage taking place would be sufficient to show evidence of intent to marry. And so once the petition is approved, then what will happen is the Department of Homeland Security will send that abroad to the U.S. Embassy in the country where the fiance resides. And so at that point, then the fiance will be applying for a K-1 non-immigrant visa. So the K-1 non-immigrant visa is a fairly, well, I guess I should take a step back and say the timeline for the fiance petition to be submitted and approved and then transferred to the embassy abroad, it does vary, and there is a little bit of there's a little bit of uncertainty that comes with just changes that have been taking place because of COVID, but on average, we're talking about a year. So from the time that the US citizen files the petition to the time that it is sent to the US Embassy abroad, we're expecting it'll take about a year. And then at that point, after a year, then the fiance abroad will be able to apply for the K-1 visa. And the timeline for applying for the K-1 visa is contingent upon the wait times published at the specific consulate or embassy in their home country. But I think also on average, it's about 3 months. It's been taking about 3 months once consulates are open and operating, if in fact they have been closed due to COVID. And so once the applicant or the fiance obtains or acquires their visa, it will be placed into their passport. It has to be a valid passport. Then they can travel into the United States. And when they arrive in the United States, at the point that they are given an admission stamp, and after they've arrived at the port of entry, then at that point the 90-day clock starts. And so within 90 days of arriving in the United States, the couple must be married and then prepare and file their application for adjustment of status. And so adjustment of status we'll get into in the next slide, but essentially adjustment of status is what permits the fiance beneficiary to apply for a lawful permanent resident status or a green card, more commonly known as a green card. Once they've arrived in the United States and they've been given their visa, then they become a green card holder. So once the, here we go, so adjustment of status. So once the US citizen petitioner and the fiance are married, then they'll file that application for permanent resident status. And so USCIS may request additional evidence of really of the fact that the couple is in a bona fide marriage is what it's referred to as. And so they want to know, is the marriage valid? Is the couple actually sharing their lives? Are they commingling money? Are they living together? How do we know that they're actually husband and wife and living, or not necessarily just husband and wife, excuse me, spouses? And are they living as spouses would? And so what does that mean? So again, they may ask to see proof that the spouses are sharing finances. They may ask for proof that the spouses are, maybe they own property together, maybe they're renting together, so like a lease. They may want to see, for example, on bank statements or on bank accounts, if you, so choose, you can make your spouse your beneficiary should anything happen to you. They just want to see legal documents or documents that have some legal effect that would indicate that the relationship is actually a marriage. And so I'm going to take a step back because I did earlier refer to the Department of Homeland Security wanting to establish whether the engaged couple became husband and wife. But I will say that it's not limited to a marriage between a man and a woman. A marriage between a man and a man, or a woman and a woman also will qualify and the couple to go ahead and apply for the fiance visa process and adjust status as well. So when the couple gets to the point at which they apply for adjustment of status, then they will be interviewed. There will be an interview at USCIS, typically at the local field office. And so the local field office is just the office that is within the jurisdiction where the couple is living. And so here locally, we are in Orange County, California, in Santa Ana, and our local USCIS office is in downtown Santa Ana. And so at that time, then the couple can expect that they will be asked questions about the marriage. In addition to other questions, there is a whole host of national security questions that are presented to the applicant for adjustment of status, who is, the fiance who came from abroad. And the interview can be, a little intimidating, but I think that, when a couple goes to their interview and they've been adequately prepared, there's nothing to worry about. These interviews can sound very intimidating, and I'm sure, people have posted their experiences in these interviews. And so sometimes these interviews are not the most positive, but I think that as long as the couple is adequately prepared, they have nothing to worry about. And so after the interview, or it could be at the point of the interview or sometime after, then USCIS will go ahead and grant the conditional permanent resident status to the fiance. And so what does that mean? It means that the fiance the former fiance, now spouse, will get a green card. They'll get that lawful permanent resident status. But because the marriage is less than 2 years old, that green card will only be valid for 2 years. And so 2 years after the issuance of the green card, then the new lawful permanent resident will have to go ahead and file what's called a removal of the condition, an application to remove the condition from their green card. And it's actually typically a joint petition filed by the couple, by the spouses, indicating that they continue to be in a bona fide marriage. There are exceptions to the condition to remove the application to remove the condition. So in the event that perhaps the couple may not continue to be married, or there's been an issue of abuse in the marriage or cruelty, or it just simply didn't work out, there are exceptions to those circumstances. And so if anyone finds themselves in that situation when it's time to file that application to remove the condition and perhaps the marriage did not continue, then definitely I think that it would be in the lawful permanent resident's best interest to talk to an attorney and find out what their options are for going ahead and presenting a waiver instead of a joint petition to remove those conditions. Okay, and so the next question sort of focuses on whether or not the fiance has children. So perhaps a U.S. citizen is filing a fiance visa, or excuse me, a fiance petition for their fiance, and their fiance has children living with them abroad. Well, the good news is the children can also be included in that fiance visa as derivatives or as beneficiaries also. And so they can also acquire the K visa. In their case, it would be the K2 visa to accompany their parent to the United States to be part of the formulation of this new family. And so children of the fiance that are under 21 and who are unmarried can go ahead and be included in that petition to apply for a K2 non-immigrant visa. The children have to continue to be unmarried and also under 21 years in order to come to the US on the visa. And also the child can travel to the US with the fiance or after the fiance, but not before the fiance. It's required that the fiance enter on the K1 visa or be admitted to the United States on the K1 visa before their child will be admitted. And then also if the fiance and the US citizen marry within 90 days of entering the United States, then the unmarried child who is under 21 may also apply for a green card as well. Okay, and so we're going to segue a little into marriage fraud. And essentially, I think excuse me there. Essentially, what's very important to keep in mind is what we should always be thinking about is what is the officer looking for when someone files a fiance petition, and this is also true for marriage petitions as well. But so when someone files a petition to bring either a future spouse or a spouse to the United States, or files a petition for them to adjust status, the number one question on the officer's mind is whether or not the couple is engaging in marriage fraud in order to obtain an immigration benefit. And so, the first thing to say about marriage fraud is we know, it's illegal. It's illegal to become married or to get married in order to apply for immigration status. And this is definitely a top priority for USCIS. So immigration authorities will definitely be requesting proof and documentation that the marriage is a legitimate marriage. And it's not, I think, perhaps it's not as typical for a fiance upon arriving to the United States once they've been issued the K1 visa to be stopped and questioned extensively at the border, but it's always a possibility. And so, sort of our advice is that at any time that someone is, having a meeting, a one-on-one with either the officer at the consulate or an officer at the border, whether it be the airport or the land border, that they be prepared to answer questions about their marriage and perhaps even have documentation that's probative of the fact that the marriage is a bona fide marriage, or that the relationship that is to soon become a marriage is also a bona fide relationship. Okay. And then also something that's important is that, I spoke a little bit about how, these days it's not uncommon for folks to present information or posts from their social media profiles. And, we find ourselves in an age where social media is just a big part of our lives. And the Department of Homeland Security's officers also acknowledge this. And so USCIS and also Department of State, the officers are looking for people's social media profiles. They are screening them. They are searching through them to see if there's anything that's posted that may negate the claim that the couple is either married or intends to become married. And so with that, it's important that you as applicants make sure to scrub your social media. I have a social media account that I do not update very often. And I think that I don't remember, but I know, after I got married, I don't think I updated my marital status or my civil status for quite some time. And so if you are married or engaged and there is an option to indicate that on your social media and it's not been updated, that is something that I've personally seen officers ask about. Photographs, definitely photographs are huge for corroborating the timeline that the applicants are presenting. And so, the point of all of this is just to say that if you do have a public social media account, make sure that there's nothing that's inconsistent on your social media account that would, that would present a problem for you at the time of your interview. Also, if it's public, perhaps you may want to consider making it private. Although I do know that in some instances, officers do request the applicant to allow them to access their social media. So if that were the case, then either way, I think just scrubbing, making sure your social media is updated and there's nothing on there that would cause an officer to question what you're presenting, then you should be okay. And the third point there is, yes, so that officers may ask for username handles and passwords to social media so that they can access that information. Okay, and so we're going to transition now from fiance visas and petitions to petitioning a spouse. And so petitioning your spouse or other loved one. So we have here the process, sort of the outline here is the process for family-based petitions. And so a US citizen can petition their spouse, their unmarried son and daughter, their married son and daughter, their parents, and their brother or sister. There is an important note to take into account, and that is if a US citizen is petitioning their parent or their brother or sister, they do have to be at least 21 years of age. To petition a spouse, it's okay to do so if you're 18. But in order to petition a parent or a brother or sister, the US citizen petitioner must be 21 years of age or older. Now, if you are a lawful permanent resident, meaning that you're not a US citizen, then you are also able to file petitions, but only on behalf of your spouse or on behalf of an unmarried son or daughter. So that means that if you have a son or daughter who is married, you won't be able to petition them, and you cannot petition your parents, and you cannot petition your siblings if you are a lawful permanent resident. And here we have a sort of a map of the USCIS I-130 processing time. Now, I do want to say that this is based on the average processing times that were happening pre-COVID-19. These projections are subject to change just because of the delays that we know have become somewhat out of control at USCIS. And so although we have seen delays and we have seen applications being adjudicated, in more time than was typical or average pre-COVID, for the most part, we're seeing applications being adjudicated within a relatively short period outside of that processing, or outside of those average processing times, depending on the application. But specific to the I-130, if you file the petition, if you file the I-130 petition for alien relative, then you should expect to have within about 90 days a receipt notice. Sorry, let me take that back. If you file your application within 90 days of getting married, then you should expect to have a receipt notice within about 30 days. Although during COVID, we've seen receipts taking up to 4 to 6 weeks to arrive. Pre-COVID, it was an average of 30 days, and it shouldn't be, you'll get a receipt notice. One thing that we've, that we say to our clients is that on average, when we file these applications, we file them with checks, because when the check is cashed, usually USCIS will print the case number on the back of the check. And so if you file your I-130 or any applications with USCIS with a check, a personal check, not necessarily a money order, then you may have access to that check through your bank, and you may be able to access that case number before you receive your I-797 receipt notice. And so you'll receive the receipt notice within about 4 to 6 weeks. And then at that point, you are just in the queue, you're playing the waiting game. And so you're waiting either for one of two things to take place. Either you receive a request for additional evidence from USCIS, or you might get a notice of intent to deny if the agency is not convinced that the documents submitted were sufficient to show that you were in a bona fide marriage. Either one of these requests, whether it be a request for evidence or a notice of intent to deny, the applicant is given an opportunity to cure the deficiency. So you can submit additional documents to address whatever doubts the officer is having. Or you may not receive a request for evidence or a notice of intent to deny, and you may receive just a decision by mail or an appointment for an interview. The decision process was taking about 9 to 12 months pre-COVID, and actually we've received some application decisions on I-130s within a year. And so, I mean, this would have been filed right around the time that COVID-19 really became present in the United States, and we have received approval notices on those applications that were filed. Okay, so the next part of our discussion is on consular processing or adjustment of status in the United States. Both processes ultimately result in the foreign national beneficiary acquiring their lawful permanent resident status. So consular processing, or the consular process, is the process by which a beneficiary that is outside of the United States may apply for lawful permanent resident status. And so how this happens is, initially the beneficiary will have a petition filed and approved. So the petition either for alien relative or the petition for a fiance will be filed in the United States by the either U.S. citizen or, in the case of spouses only, the lawful permanent resident. And they will wait for that processing time to transpire, and then they'll get an approval notice. Once the approval notice is received, then the Department of Homeland Security will transfer that case to the Department of State. Typically, it's the National Visa Center that handles, or the National Visa Center is the agency that processes these immigrant visas, or non-immigrant visa in the case of the fiance, and then an interview is scheduled at the consulate. So I'm going to shift, I'm going to refer, going forward, I'm going to refer now only to spouses, not fiancés. And so in the case of a spouse, the I-130 is approved, and once it's sent to the Department of State, that is because the petitioner has successfully established that he or she is in a bona fide marriage. Okay, so it means that he or she was able to establish that they are married to an individual, and they are living as a married couple. They are not, they've overcome any doubt that the USCIS officer may have had about whether or not their marriage was legitimate. And so typically the consular process is required when the spouse is not in the United States, or they are in the United States, but they were not admitted at the time that they arrived. And so they have to leave the United States to go to the US Embassy or consulate abroad to get an immigrant visa. So there is, with that second scenario in which I said that there is a spouse living in the US, they were not admitted on a visa, but they're here, perhaps they entered, without presenting at the border. And so they did not present to an officer at the border, but they're here, and they have to then leave. That is something definitely that you should talk to an attorney about, because if someone is in the US without status, okay, so they don't have a visa that's valid for 180 days or more, then they may be subject to penalties if they leave the country. It's actually an unlawful presence bar is what it's called. So if you've been in the US for 180 days or more without status and you leave the US to attend an interview, then you may be subject, or you probably will be subject to the unlawful presence bar. And so you definitely want to consult an attorney about whether or not you need a waiver of unlawful presence to cure that bar, so that when you present at the embassy or at the consulate abroad, then your unlawful presence will be cured and you'll be able to return to the United States without fear of being refused entry, or even before that, you'll know that you'll be able to return to the United States and that you'll be given your passport with a visa issued. Okay, so going back now. So if you are eligible for the consular process and you've consulted with an immigration attorney and you're confident that you will be able to travel to the consulate or the embassy and return, then what happens next is that even though you filed an application with the Department of Homeland Security, you'll also have to file an application with the Department of State. Okay, so the Department of State has its own set of requirements, and the form that must be completed is the DS-260. Once you complete the DS-260 online, you'll also be able to submit civil documents. There are a number of civil documents which, include birth certificates, marriage certificates, all electronic copies, police clearance letters, or, if there has been any kind of criminal history, then certified copies of any criminal documents will all be required, in addition to other things that are listed on the Department of State's requirement list, checklist, that you'll have to submit prior to being scheduled for an interview. You'll also have to pay the Department of State fees. And so depending on the application, currently the fees for an immigrant visa are $325 for visa processing, and then $125 for an affidavit of support. And that's a separate fee, or those are separate fees from the fee that you paid, or that the petitioner will have paid for the petition in the United States. So then once all the documents are submitted to the National Visa Center online, then the applicant will be scheduled for an interview. They'll attend their interview. They should be prepared for their interview. And that can, that preparation will happen with their attorney or a BIA accredited representative. And they will be given instructions on what documents to bring with them to their interview. They should bring their original marriage certificate, original birth certificates to show that those documents are valid documents. And assuming that they satisfy, all of the expectations of the officer, then they will be approved. Upon approval, they will leave their passport with the officer, and the officer will then process the passport for having an immigrant visa issued and placed into the passport. And then after a few days, they'll receive their passport and a visa packet, typically by courier. So once they receive the visa packet, they should not open that visa packet. They will take that packet with them to the United States border or port of entry, and the CBP officer or Customs and Border Patrol officer will determine if the applicant or if the recipient of the visa should be admitted, and then allow them to enter the country. There's also a fee for the green card. I believe it's $225 now, and that fee will also be paid after the interview, but before the applicant or before the beneficiary enters the United States and requests that admission. We have here a immigrant visa processing map, and so it shows basically the steps for acquiring a lawful permanent resident status through the consular process or non-immigrant visa process, the immigrant visa process. It's quite lengthy. On average, depending on where the beneficiary lives, the process overall, I think, depending also on whether or not the person needs a waiver, it can range from anywhere to a year and a half without a waiver, to 2 to 3 years if they require a waiver. The waiver, again, is the waiver for unlawful presence if the applicant or beneficiary, I'm using those words interchangeably, but if the beneficiary has been in the United States without status for 180 days or more, they're going to require a waiver, and that is on this processing map, it's indicated as the I-601A waiver. There are other waivers that are available to folks that we're not going to get into in much depth for this presentation, but if anyone has any suspicion that they may have issues beyond just being in the U.S. undocumented or without status, and perhaps they think that they might need a different kind of waiver, then they should absolutely talk to an immigration attorney. And if you're not sure, if you have no idea whether or not you might be subject to any kind of ground of inadmissibility, or you might have issues getting a visa, an immigrant visa, talk to an attorney anyway. I think that this process, as doable as it may be or as folks may think it is, I can't tell you how many times, we've gotten phone calls from applicants who are stuck outside because they didn't know all of the intricacies of this immigrant visa process. They didn't know that they needed a waiver, or they didn't know what kind of waiver they needed, and now they have been denied and they cannot get back. So it's highly, highly recommended that anyone seeking to file a petition on behalf of a spouse and knows that they'll have to travel to travel abroad or not, even if they don't have to travel abroad and they're going to do the adjustment of status process in the United States. Regardless, I think it's super important to consult with an immigration attorney just to make sure that everything is good and they're not facing any kind of bars or possibilities of denial. Okay, and the next question then, we are now segueing into who can adjust status in the United States. So individuals who are in the US, who are in legal status, and there are some exceptions to this, but typically individuals who are present in the US in status, they have not fallen out of status, can adjust status. And that means that they can apply for their green card in the US without having to leave. There may be some exception to this if the beneficiary of a spousal petition was a J1 visa holder, and their J1 had a condition that required them to return to their home country for 2 years. Then they may not be able to adjust status, or they may need to seek a waiver of that home stay requirement. Okay, so individuals who are in legal status in the US are one group of applicants who can do so, or who can apply for a green card without individuals who are immediate relatives of US citizens. So immediate relatives, despite what one's intuition would tell them, but immediate relatives are legally defined in the Immigration and Nationality Act as a parent, a minor child, so in this case, a child under 21, or a spouse. Okay, so if you have a child who is 21 or older, they're not considered an immediate relative for immigration purposes. And also siblings, brothers and sisters, are also not considered immediate relatives for immigration purposes. So individuals who are immediate relatives and they last entered the US lawfully, even if they fell out of status, can still apply for adjustment of status in the United States without having to leave. Other folks who may be eligible to adjust status in the United States are victims of violent crimes, including domestic violence, who seek to immigrate on that basis, and individuals who had an immigration petition filed on their behalf with the US government on or before April 30th, 2001. So these four categories basically cover who is able to apply for a green card in the United States without having to leave the country, without having to do the consular process abroad. So adjustment of status in the United States is the process by which a beneficiary can apply for their lawful permanent resident status or their green card in the US. I've said that a few times now, but just to really hone in on what that means, adjustment of status, it means you get your green card without leaving the country. So first, you should determine if you're eligible to apply for a green card, if that's through a spouse, through a spousal petition, or there are also some exceptions, and that would include someone who can file a self-petition because they were married to a lawful permanent resident or a United States citizen who inflicted extreme cruelty on them, whether it be physical or emotional. The immigration petition must be filed. And then once the immigration petition is filed, and actually I should say the immigration petition as well as the application for adjustment of status, they should be filed. Depending on the class of, depending on whether, what category the individual falls within, they may be able to file their immigration petition and their application for adjustment of status at the same time. So if you are an immediate relative, then you're able to file those petitions together. However, if you are not an immediate relative because your petitioner is not a US citizen, but rather they are a lawful permanent resident, you may not be able to file those applications together if there is a wait list according to the visa bulletin, the Department of State visa bulletin, which is something you should discuss further with your attorney. Once that application or those applications are filed, then expect an interview to be scheduled. And then at that point, you would be expected to take additional evidence. So from evidence that would include the span of time from when you filed your application until the interview, which is approximately a year, to show that the marriage or the marriage is bona fide and continues. And so updated documents could include taxes, income taxes, bank statements, credit card statements, leases, like titles for property, insurance documents, those types of sort of those things that have legal implications and that show that the couple, that they're addressed to both individuals in the married couple. And then after your interview, then you should expect to receive a decision. The decision can be issued the day of the interview, or it could be issued thereafter. Depends on the officer. It's not uncommon to get a decision the day of the interview, but it's also not uncommon to get your decision later. And so if the officer needs to see more evidence, or perhaps, they have to run prints again, and they can't give the decision that same day, it's not something to be concerned about, or it's not something to panic over. It's very common that happens. Okay, and so the processing time for the adjustment of status process, again, once you file your petition and application, you'll receive a I-797 receipt notice within about 30 days. And then you'll receive an appointment to fingerprint. And so you will present at the application service center with your ID, a valid government issued ID, so that you can be fingerprinted. And then you'll wait for a period of time that could range from anywhere to 9 to 18 months for an interview. On the USCIS website, there is an indication that the processing time for the adjustment of status application can be up to 36 months, at least here locally in California, in Southern California. I haven't seen or heard of anyone's applications taking that long to be scheduled for an interview, but I think that, anywhere, past a year could be up to 14 to 18 months, and it wouldn't be completely shocking just given the backlog currently. At the time of the interview, again, you could be approved, you could be asked for more documents, or you may just have to wait for the officer to get to issuing that decision. Typically, USCIS instructs someone to wait at least 120 days before filing some kind of inquiry or an info pass to find out what the status of their case is. Okay, and so there's some other considerations also that go with, or that, sort of go hand in hand with petitions that are filed based on a relationship with a U.S. citizen or lawful permanent resident. The one that's sort of on everyone's mind as of 2020 and maybe slightly before is the public charge test. So public charge is a ground of inadmissibility that USCIS may invoke if they suspect that the person who is applying for the green card may become dependent on government benefits or government assistance. And so individuals who are over 61, who don't speak English fluently, who are not employed, perhaps don't have a high level of education, or even were not able to graduate from high school, and have medical conditions, may be denied their residency. Essentially, immigration is looking to, or is evaluating, and it's all sort of a balancing test. They're evaluating whether or not the individual will be able to work, whether or not they'll become gainfully employed, based on their education level, their language ability, their ability to speak English, their work history, and then their health. And so if it's difficult to say that anyone who has received public benefits in the past will automatically be denied. I don't think that would be fair. However, if anyone who is applying has received public benefits, or if any member of their household has received public benefits, I strongly recommend that they talk to an attorney before applying, because the public charge ground of inadmissibility is quite harsh. There is not a waiver for that. And so, yeah, I definitely think There is a bond, but I think that you should consult an attorney if you suspect or if you are concerned at all that that might be an issue. There's a lot happening around the public charge topic currently. The most recent change to the public charge test occurred in February, or went into effect in February of 2020. And there is buzz about the current Biden administration seeking to scale back the current public charge test. So yes, definitely, I think it's important to discuss this with an attorney if you are interested in applying for a green card. Another consideration that's on the list is VAWA, and VAWA is a set of applications and benefits available to victims of physical, verbal, or emotional abuse by their U.S. citizen or lawful permanent resident spouse or parent. VAWA benefits were created under the Violence Against Women Act and may be an alternative to individuals who are married to a U.S. citizen, lawful permanent resident, and who are now finding themselves subject to this kind of abuse unexpectedly, or who feel like they can't get out of the marriage because they're afraid about their legal status, and that's perhaps even something that may be being used against them. And so VAWA is another consideration for individuals who may find themselves in this kind of situation of abuse. Another consideration is the U visa. And so victims of violent crimes who cooperate with law enforcement in investigating or prosecuting the crime may also qualify for a non-immigrant visa, which ultimately leads to eligibility for lawful permanent resident status. And so anyone who has been a victim of a crime, who reported the crime to law enforcement and who cooperated with law enforcement may be eligible for a U visa, and should also discuss that with an immigration attorney or a BIA accredited representative. And then also another consideration is an application under parole in place, or PIP. Individuals with immediate family members who are serving or who have served in the U.S. Armed Forces may qualify for a parole document, parole in place. And the reason that that's important is because if someone is issued parole in place who did not enter the United States legally, or who is not in legal status, then is given admission, is admitted to the United States for the purpose of filing an application for adjustment of status, or which would qualify them to file an application for adjustment of status without having to leave the country to do consular processing and without confronting the possibility of needing an unlawful presence waiver. And another thing that we at U.S. Immigration Law Group find or think that is incredibly important is offering our community just a list of other steps that they can take with respect to preparing for any kind of application for immigration, or the possibility of becoming legalized and acquiring legal status. And our main points are to become educated, get educated, and stay abreast of changes in the law. Perhaps you have consulted with an immigration attorney, and perhaps that attorney told you that at this time you're not quite eligible to apply for relief or benefits, and that's okay. As disappointing as that may be, you never know when there could be some change in the immigration law that could benefit you. And so although changes in immigration law don't come frequently, there are, at least in my practice, in the time that I've been practicing immigration law for the last, the last 7+ years, there have been changes in policy that have had great impact on people's ability to become legalized. One way to get educated is to participate in webinars such as this one, to follow immigration law firms that are reputable on social media, visit their websites if they have publications on changes in immigration law or just things that are important to know. I recommend immigration attorneys as being a source of information. The news is also a place where many people get information about changes in immigration. and that's wonderful. I just recommend that once you hear, once you've heard a report, then contact someone who is, whose career depends on knowing immigration law, so that you can be assured that you're getting the right and relevant and up-to-date information. Be prepared. So don't wait to gather documents. A lot of people will come to our office and they will have purged all of their important documents for the last 10 years and they have nothing. They have no medical records. They have no, copies of their bank statements, of their expired driver's licenses, and these kinds of things are all documents that they've gotten rid of just to make room. Spring cleaning. It happens all the time and we all do it. However, immigration typically requires evidence of applicants' continuous physical presence in the United States. And how do you show that you've been physically present in the United States? Old documents. And so it's important to start gathering information and documents now. And that way you can make sure that at the time that you may qualify, you'll have what you need to submit your application. And if you don't want to have boxes and boxes of papers and documents, scan them, take pictures of them, do what you need to do, but make sure you have a record of your physical presence for at least the last 10 years. Have a plan. Enroll in school if necessary. In 2012, when the DACA memo was published and people were able to apply for deferred action for childhood arrivals, one of the requirements was that they were in school, that they had a high school diploma, that they had a GED, or that they were in the military. And so, some folks who maybe didn't finish high school were able to still apply for DACA if they enrolled in a GED or a high school diploma program. And so if, there's any potential that you'll need to be able to show that you have either of those, then enroll in school if you need to, so that that's not something you're worried about at the time of an announcement of some change in benefits for either people who have already had DACA, or if there's an expansion of the DACA program, it might be in your interest to take care of that now. And also use your voice. Share this information with family, with friends, and your community. And not only share it with them, but do something with that information. Contact your representatives in Congress, because we know that ultimately the future of immigration is in the hands of our representatives in Congress, in the Senate, and the House of Representatives. And so contact your representatives and have your friends and family and colleagues contact their representatives and voice what they want to see, what they want to happen with respect to immigration law. It's, I think the future of immigration depends on it. It depends on accountability and holding our representatives accountable. And lastly, we have our firm's information. So actually, this is the information of my colleague, Lisa Ramirez, who is one of the owners of the firm and is just a lovely person to work with. And so her information is here. My information is also on our website. So if you visit our website at www.usilg.net, you are welcome to schedule an appointment with us if you would like to have your immigration questions answered. You can call us at our phone number, 714-494-4545, also to make an appointment, or you can visit us at any one of our social media profiles on Facebook, Instagram, or Twitter. And you can follow along with us as we observe any of these, what we hope are changes in immigration law, positive changes in immigration law, as are being sort of formulated, presented, and discussed currently. And also to participate in any kind of future webinars such as this. We have a year full of presentations. It's critical, and it's so important for us to be able to disseminate important information about immigration law and immigration, individuals' rights with respect to immigration. And so fortunately, we are in the social media age, and we can provide and we can present this information via these channels. And so we are incredibly grateful for your participation today in this webinar. And we look forward to working with you. We look forward to being part of your immigration story. And so thank you, and have a very happy Valentine's Day.